In 2018, Inga Holstracher was allegedly raped by a man she met through an online dating site. However, the accused was acquitted due to the state's failure to prove beyond a reasonable doubt that there was intent on the part of the accused. Now, Holstracher, along with NGO Embrace Project, will intensify the fight against gender-based violence before the Constitutional Court.
The rate of rape convictions in our country sit at 1% of the number of rapes that are reported to the police annually. And that is bearing in mind that a lot of victims don't report rapes to the police. And a lot of the times we receive reports of the police refusing to open up a case of murder. A case of rape. So those numbers that we have, which is approximately, I think, 40,000 cases of rape are opened up with the SAPs annually, is probably quite a severe understatement of the number of rapes that are perpetrated in South Africa and the conviction rate. The number of these perpetrators who are actually found guilty of rape sit at 1%.
The applicants argue that one of the reasons for the shocking statistics is the legislation where the test is subjective, looking at whether there was intent on the part of the accused to commit rape. They want the Apex Court to confirm the declaration of constitutional invalidity of an order granted by the Gauteng High Court in Pretoria in September last year.
What we want going forward, while these corrections are made, is that if you're going to raise a defense of consent, if an accused person is going to say, no, well, they understood the complainant to be consenting, we have now asked for a reading in where the accused will actually have to show the court that they took reasonably objective steps to ascertain consent.
But there is a test for objectivity, the reasonable person test. This poses two questions. One is whether a reasonable person in the same situation as the accused would have foreseen a lack of consent and therefore the harm caused, and whether a reasonable person would have taken steps to prevent the harm. But some disagree with this approach.
And the Women's Legal Center actually raises challenges with these steps because the reasonable steps to ascertain that there is concern. And in their case, they are arguing that this can actually make the situation harder for rape survivors. So that's not necessarily kind of the argument, but it's the remedy that the High Court has presented.
But while many agree that the law needs to change, there are disputes about how it should. The Center for Applied Legal Studies wants consent to be removed as a definitional element of rape. This as rape is defined as a person who unlawfully and intentionally commits an act of sexual penetration without consent.
So with regards to the definition that Culs prefers, actually, and we really want a coercion approach, is we can find precedent in other African countries around us. So Southern African countries actually do predominantly use a coercive approach. So Culs suggests borrowing from African countries. Amazingly enough, or maybe not amazingly enough, if we look at decolonialism, is that a lot of the Western countries do use this archaic type of definition that still includes consent in its definition, although it's different to other violent crimes. So I would dare to say that Southern Africa is maybe the leading jurisdictions on this point. And it would be great for us to borrow from African brother and sister countries, or sister countries, yeah.
The High Court, however, dismissed the Centre's application last year, ruling that it would be a violation of the separation of powers principle, as South Africa uses the consent-based model in matters of rape, therefore making it a policy decision. For Newzroom Afrika on Channel 405, I'm Zoleka Qodashe in Johannesburg.